Welcome to Professional Development Hour presentation brought to you proudly by the Atlanta Metro chapter of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. Before we begin, we'd like to let you know that any opinions presented tonight are solely the opinions of the presenter and not that of the Georgia Society of Professional Engineers, the National Society of Professional Engineers, or any other of its affiliates. We certainly hope you will enjoy tonight's presentation, so sit back and relax, and on with the show.
Okay, thank you. It's so good to be with you guys today. Can everybody hear me all right? Sometimes I have trouble projecting. Say again?
You might have to talk loud.
I will? Okay, all right. Okay, just do this if I need to shout, okay? So as Zeus said, I'm general counsel for Pond. I'm their first general counsel. They've never had in-house counsel before, so most of my work entails yelling at people and saying, stop that, do it this way. They've been very good to me, very kind people. So what we're going to talk about today is the basics of contracts and how they help you manage your business risk. So again, that's me, just so everyone's clear. I've been at Pond for about 3 years. Prior to being at Pond, I was at the Smithsonian for 9 years. And what I did at the Smithsonian was I was detailed to the facilities division, and that means that I sat with the facilities guys, the engineers and the builders and the construction managers. And I wrote contracts, and I awarded contracts, and I helped answer RFIs, sort of just helped everybody do the legal part of what they needed to do. The biggest project I worked on at the Smithsonian was the revitalization of the National Air and Space Museum, which was a very complex project. All we had to do was reclad and reglaze the building while replacing the HVAC and heating systems. We were also tasked with moving all of the collections out and then moving them back in. The thing that sort of set all of this in motion was these marble panels are not supposed to be curling out of plane. It's unhealthy. People don't like that. The earthquake in 2014 brought these tiles to a lot of people's attention as a falling hazard. So over time, the project sort of morphed into this just complete redo of the entire 600,000 square foot museum building. The head of the museum compared it to flying a plane while you're building it. The larger part of this was moving all of the gallery items out and then moving them back in. As you may have heard, gallery items or collections items have to be maintained at a very strict humidity and temperature level so that they don't degrade. So in some cases, we had some of these larger artifacts were actually, they were secured in place. And right out of this corner, there are these two rockets. One of them is a Soviet rocket and couldn't be moved without permission from the State Department, so that one got its own environment. Anyway, I believe they're slated to completely reopen this year, but so far the project is more or less on time and on budget, so I hope I contributed to that in some way. Alrighty, this is the part where I tell you I am an attorney, I am not your attorney. If you need legal advice, you should get it from an attorney that knows you and knows your project. What I'm going to share with you today is just some general information, how contracts can help you. We're going to hit some of the high points on some of the more critical elements of your contracts, the places where you can get a lot of bang for your buck if you spend some time. And then we'll have just a few takeaways, I hope. So I was talking with somebody earlier who said that they had studied what they called business law in school. And so I'm going to go over a couple of real basic contract slides before we jump into the nuts and bolts. Contracts are, if you go to law school, Contract 101 is, it's just an enforceable promise. It's a promise you can take into a courtroom and have a judge enforce it. You're promising to do something or not to do something in a way that a court can pick up and say, okay, we know exactly what's going on, you screwed up or you didn't, and take it from there. Am I going too fast? Does anybody have any questions so far? Okay. So when you form a contract, they're going to share this sort of laundry list of common law standards with you. This set of terms is as old as the hills, and you will see it come up over and over again. But the way you form a contract is traditionally offer, acceptance, consideration, and this is a mouthful, the objective manifestation of intent to be bound. So to put that in context, the offer is your proposal. The acceptance is your client saying, yeah, we can do this. The consideration is your fee. Typically, the objective manifestation of the intent to be bound is the contract that both parties sign. And when they sign that contract, they have to not be drunk or crazy or otherwise under duress. It has to be voluntary. The people have to have capacity, and the purpose has to be legal. There are a couple other issues that can void your contract, but those are the sort of top three. You can have an implied in fact contract. You don't need to write it down. I would not recommend this for a variety of reasons. One of which is if you actually have a contract dispute with an implied in fact contract, it can actually be harder to prove that you have a contract than if you just have it written down somewhere. It's actually more important in the long run. It takes you probably less time to just negotiate that written manifestation, that written contract, and get it down on paper. All of Pond's contracts are in writing that I'm aware of, and if not, we're going to have to talk to somebody. But that's typically my perspective. I think it's pretty obvious, especially for engineers, that a written contract is just much, much easier to enforce. You guys deal with clients every day. The expectations are out here. The practical realities are somewhere way smaller in there. What an engineer does, what they don't do as a matter of course, is something that clients need to be very clear on. So to that extent, when you have a clear scope and a clear contract, it really can help you avoid confusion, can avoid hurt feelings, wasted time, that kind of thing. So what I hope you'll take away from this, and not just because I'm a total nerd about contracts and I think they're wonderful and I could read them until the end of time, but I know not everyone feels that way. But contracts can be tremendously valuable for running your project. They become the rule book for your project. In addition to the legal looking parts, you also have to make sure that you have the scope and all of those other fun exhibits that come along with it. So if the contract is the rule book, you have to make sure you read all the rules, right? So understanding your scope to the smallest detail is as important, in my observation, as good terms. When you look at different forms of contracts that come in from whomever you get them from a client or a prime contractor, you can sort of watch them. They do different things, right? If you have a master services agreement, you probably have somebody who's running a lot of little projects. If you have a standalone agreement, you probably have a lot of larger, you have a big complex project. If you have a task order contract or a series of task orders or purchase orders, you probably have a ton of little low risk engagements. For the record, I do not recommend purchase orders for AE work. Typically, they are drafted for a product. For reasons we'll get into later, we do not treat A&E services as a product. When we do that, bad things happen. There are a lot of different contract delivery methods available these days. You'll hear a lot of people say things like, oh, integrated project delivery, or construction management as agent, or design build. And they'll tell you chapter and verse all the time, well, design build always means X, or construction management at risk is always open book. This is bupkis. You can do these things any way you want, but the important thing is clarity. Especially if you shift to these different kinds of roles, you need to make sure that everything that's in that contract is accessible and understandable to both you, your client, and your partners. I have sort of a recurring theme in my office. Somebody will come in and say, I've got this project, it's not going well, I don't know what to do. I'm gonna talk to the attorney, and then she's gonna come in and wave a wand. She's gonna find that part of the projects that makes that thing I don't like stop. I refer to this dynamic as the smackdown clause. There is no smackdown clause that I have found so far. I've been writing contracts for much longer than I care to admit. I've never written a smackdown clause. I've never found a smackdown clause. I don't think I'm ever going to find one. So that's bad news for Brock Lesnar. But we have in our contracts typically, almost always, ways that we can communicate with the client, ways that we can ask for a modification. We have procedures for dispute resolution. We have all kinds of tools for mitigating risk when bad things happen. And we have our insurance requirements. So while I can't just wave a wand and make everyone behave, you do have tools that help you monitor what's going on, talk to people, throw a hand up when something doesn't feel right, and putting it on paper is probably the best step with all of those things. As foreign as that might seem to you, that is typically how we run things with contracts. So this is probably not a full list of our most common contract negotiation issues, but in my observation, they are the most important. The first concern is going to be the standard of care versus warranty. Secondarily, we're going to talk about indemnity. Indemnity is definitely the lion's share of this discussion. We'll get into that, the reason for that in a minute. And then finally, insurance. So when you're an engineer, you're not churning out widgets, right? You are researching and calculating and writing and making recommendations. You can't promise someone that the end result is going to look a certain way. For that reason, the law has decided that professional engineering services are subject to something called a standard of care. It means when you don't live up to that standard of care, you get hit with a negligence claim. On the construction side of the house, the construction builder warrants his work. This means he says to the owner, I promise this work is going to be of good quality and it's going to be free of defects. It's going to have these certain physical characteristics. There are going to be times when you have somebody who just doesn't care about the standard of care versus warranty issue, and they're going to try to saddle you with a warranty that would be suitable for a builder. You see this a lot of times with the government. They have one contract, they don't understand why you won't sign it. For reasons that we'll touch on later in the presentation, warranty issues can really foul up some things economically down the road. It happens often enough that I don't think it's like, absolute death knell to your insurance claim, but it can make things really complicated and much more expensive than they need to be. So getting to indemnity. Indemnity is it's just a promise to stand in for somebody. So basically the idea is, when you're working with an owner, the owner doesn't have engineering expertise and they want to level the playing field a little bit. The way they do that traditionally, this is a very old risk allocation mechanism, An indemnity is the agreement where you say, I, the engineer, I'm going to cover you. I'm going to stand in if you get sued because of a mistake that I make. Now, what ends up happening is that the owner wants you to be on the hook for a lot more than the mistakes that you make. When they shift the risk from the engineer, or when they shift the risk of loss from the owner back to the engineer, they want to say anything that goes wrong is going to belong to you, engineer, because I'm really not going to understand what's happening and you're going to be in the best position to fix all of this. Well, yes and no. We want to be on the hook for what we mess up, for our negligence, right? Because we're subject to that standard of care. But we don't want to take on board anything that is the owner's fault, as an example, or anything that we couldn't control. Things that are realistically outside of our efforts should be left out of the indemnity conversation. So the way we do that is we look at three parts in the indemnity. We look at who's indemnified, we look at what they're indemnifying, what they're being indemnified for, and then what triggers that duty. So this is the audience participation part of the presentation. I apologize that you guys can't see this real well. I didn't realize we were going to be on a projector. But on the, I think this is your left. On the left, we've got a fair indemnity clause. And I've grayed out what I consider to be a reasonable list of parties that are included in this promise to make good on your mistakes. The owner, the officer, directors, managers, and employees. Well, sometimes in unfair indemnity clauses, you'll have contractors, consultants, lenders, successors, and assigns. I've reviewed contracts where shareholders were included for publicly traded companies. No, thank you. Yes, sir.
Under Georgia law, as of several years ago,
yes,
broad-based indemnification clauses for design work, architects and engineers, was ruled by the legislature to be contrary to public good and therefore unenforceable.
That's completely true. However, what I have seen in response to that legislation is bold language that the client wants you to use to waive that right. So whether that is appropriate or not is something that you will have to litigate, right? You're going to court whether you like it or not. If you do any work in Texas, there's an oil field anti-indemnity act that has an express provision permitting you to waive that right. I don't think it's ever been tested as to whether the construction anti-indemnity in Texas will overrule the oil field indemnity, but it's a great statute. I've talked to the guy at ACEC who helped write it, and they're very proud of it. It's fantastic. But it still has to be enforced in a court of law, unfortunately, because owners aren't taking it lying down. I will tell you, I've seen exactly 2 or 3 contracts from big companies that are like, yeah, okay, anti-indemnity statute, let's go. You would think that it would be easier to write a contract that you could just use to get along and sort of get over to the next step when there's a claim. But, people are very, very concerned about things they may not fully understand. And I think for that reason, they like to keep those indemnities broad. Does that make sense? Okay.
I had to step away from the client because they kept putting it in and I kept taking it out.
I've been there recently, yes. Yep, absolutely. So we're gonna go to what we're agreeing to pay for when we indemnify. In an ideal world, you're limiting your indemnification to third-party claims. This is, let's say, in the non-design world, you slip on a banana peel and you knock over a little old lady trying to cross the street. And so she turns around and she sues you and the owner because of your quote-unquote negligence around this banana peel. That would be an example of a third-party claim that we would appropriately indemnify the owner for, right? There's that chain of events in which our purported negligence connects that owner to that lady. Can I help you, sir? Okay. No. All right. Now, typically what the owner wants is for you to be on the hook for any claims, no matter what, whether they're indirect or direct. So that means they can say, you know, this happened, this terrible thing on the site happened, and because you were on this project, you owe us an obligation of indemnity. That covers a lot more ground. The reason why they do that is because they don't want to take the time to sit and parse out who did what. I have that issue with our subs sometimes. You don't, you know, this one says you stole my stuff, that one says no, I didn't. They're not paying each other. You just kind of want to be done with it. However, as AEs, it's much more important. You have a lot more skin in the game on this negligence thing. So it's important to make sure that you're limiting what you're paying for to third-party claims, damages, losses, expenses for which the owner may become liable. I see some confused faces. Do we have questions? No? Okay.
How does that differentiate between direct and indirect, the fair indemnity clause? How does that statement depict between the two?
So direct damages would be things that are directly related to that claim. So like medical expenses if someone is injured, or the costs of repairing something that was broken. Indirect damages is a lot more diffuse. It can be lost profits. It can be, you know, we lost a day on the site that day, so our operations won't start up as fast.
Or another contractor.
Correct.
Thank
Yep.
you.
Mm-hmm. And then finally, what are you agreeing to pay for? Appropriate limitations on indemnities are traditionally property damage and personal injury, as opposed to any and all third-party claims, damages, expenses, anything at all. So you want to make sure that you're not just focusing your concerns on who is included in the indemnity, who can bring the claim, and then what kind of claims they are. You want those three capabilities of restricting what you're indemnifying for. The duties typically triggered by our negligence. If we screw up, we typically want to make it right. With a fair indemnity clause, you really don't worry about doing that, right? With these larger, more diffuse terms, anything that arises out of or resulting from this agreement, whether or not you was even caused by you, can end up on your doorstep, meaning the owner can screw up and you end up with that claim. You end up defending that claim. Is that, I see concerned faces. Yeah, okay. I think we're following.
Slide for just another second.
Sure.
Okay, great. Thank you.
Lest you think I am overstating this point, these are provisions from real contracts. The broad form indemnity is the worst type of indemnity. You see them all the time. There are a number of states, as Mr. Grabman has already told you, that have decided it's against public interest for an owner to require that its contractors or its designers take on its liability, and they've passed legislation that says if you require these kinds of provisions, they're just void. Not everyone has gone along peacefully with these efforts. So you're still going to see these broad form indemnity agreements in your contracts typically. And to the extent that you can push back on any of these provisions that open you up to liability, any one of them is fair game. Ideally, what you want to do is align the contract term and the language from your insurance policy. So on your left, you've got a professional negligence indemnification provision. And then over here, you've got language from the professional liability policy. This is what they'll pay for, right? So the closer you get these two documents, the closer they follow each other, the less you have economic liability. The more daylight you have between these two things, the more exposure you have. When lawyers say exposure, liability, that's typically what they're talking about, uninsured liability. So here's your list of scope openers on indemnification provisions. When you push back on these, you will sometimes immediately just get, no, we don't make changes to this provision. If you are in a position where somebody is just really strong-arming you, look to the choice of law. And to the point that Mr. Graben made earlier, if you can get choice of law into one of these states that has an anti-indemnity clause, you have a better shot when you get to court. Because you're choosing a forum that will be sympathetic to your plight. So Georgia is a good one, Texas is a good one, Florida has a really nice one. There are others, they're out there. So there are 2 slides on defense because attorneys really hate this word. Defense means that the indemnification obligation is triggered by an allegation on its own. No one has to file anything. It literally just means, you wronged me. I call you on the phone, my subcontractor's upset. You're on the hook. Anytime you can, get a defend out. Additionally, in professional liability insurance, which we're going to cover in a minute, defense costs associated with defending an owner are typically not covered because of the way that the policy is structured. So getting to insurance, our final concern. Insurance is one of the oldest types of risk management mechanisms. There are, decades and decades of insurance law available. If you really need to cure your insomnia, I have some things you can read. The idea with these with policies is that everybody pays in to these pools, right? And they protect you against specific risks. So as the claims come in, then the pool is the source of the payout. Exclusions associated with the use of that pool are designed to keep the pool robust. So if you deplete it with stuff that's not included in the calculation, there won't be money, theoretically, when one of these real risks happens. Now, one of the downsides with insurance is that basically the more likely the risk, the more expensive the policy. But with regard to exclusions, that's kind of where we're going to tie up a couple of our loose ends. We need to make sure that you're not in a field where the claim is going to be excluded. Usually when you sign an agreement, there are going to be requirements for general liability, commercial general liability, probably have auto, workers' comp, professional liability. If you're working with any kind of fueling or any kind of volatile chemicals, you might have pollution liability. If you are involved in some kind of design build contract and you're doing any kind of work that touches on delivery of equipment, you might want to, and it entails rigging or a crane, you might want to consider figuring out who has rigging insurance. But the idea with each of these is they have what's included and what's not. So the general liability is going to exclude things like arson or liquor liability. Also, a common type of exclusion is I can't make a claim on general liability when that claim's covered by pollution. I can't make a professional liability if the claim isn't related to engineering services. So going back to the warranty slide, can you think about why that might be a problem?
You're exposed without coverage.
Exactly. Most of our insurance folks are pretty good about us saying, you know, we tried to get this out. They didn't go for it. They're not completely draconian. They will help you. They can give you resources. It's incredibly important that you understand how your policy works. To that end, your broker can be a really good resource. Something to think about. When you look at insurance provisions, you want to make sure you have the policies they're requiring. If you're using a drone, you need drone insurance. If you're, going to be moving equipment on a barge, you're going to need maritime coverage. Just make sure when somebody says, oh, we've got this cool new thing coming in, that you're not just thinking about the cool new stuff you get to do. Also maybe consider the exclusions on your existing policies. Sometimes I joke at work that part of my job is destroying people's dreams. And that's part of, the question, are we insured? That's a question you can answer if you know who to call, if you've got a broker who's a good resource for you. But it's a question you should know how to answer. And a lot of times it can be as simple as, we have to get this policy, Mr. Owner, because you've required it in your agreement. Do you really need it? Sometimes they say no. And then sometimes if they say yes, you can just say, well, we don't have that policy. Can we pass that cost through to you? Anyhow. Up, go backward, okay. So what I'm hoping that you're gonna come away from here is the importance of knowing your scope. Understand how important it is that you just talk, understand how the contract works, know how to talk to people. There's no smackdown clause. Your engineering role is tied to a standard of care. Try to make sure that's what the contract says. And then finally, align your indemnity clause with your insurance. If I had a magic wand that I could wave, one of the things I like to tell people that I work with at Pond is that it's okay to ask questions. Do not get intimidated by the long words and the stuffy contract managers. Ask those questions. Make an attempt. Redline that contract. Even if you don't get changes, it will help you understand who your client is, what their concerns are. Sometimes contracts are just a list of every bad thing that has ever happened to someone in a business. When was the last time you guys had to enforce this provision? That's always a good question. Well, back in '04, during the Great Blizzard of, this happened because this guy ripped us off. And so you'll know, okay, this isn't a huge deal. I may not have to worry about that as much. Even if you end up signing agreements that may not be great, you need to understand what the risks are and how much they might cost. And that's all I have.
How much do you guys use boilerplate contracts in your business?
We use boilerplate for all of our subcontracts. And typically if people ask for changes, we will consider them. Yes, sir?
Put the last slide back up. I failed to read it.
Okay, no problem.
What would you
consider
an engineering company should have minimum types of contracts?
It would depend largely on what you do. If you subcontract people a lot, I would make sure you have a standard template for subcontracting. If you hire people who do repair work, make sure that it's like you have a warranty contract and a standard of care contract. We don't always have clients who have their own contracts, so we have a client style agreement that we can use if we need to. But if you NDAs are great. Typically, those aren't really very difficult to obtain. If you have concerns about maybe where to get started with these, like the EJC, the Engineers Joint Committee on, I can't remember what it stands for, the EJCDC, the AIA contract groups, they might be expensive, but they can save you some money. Just think about it. Yes, sir.
What is your thought about AIA contracts, especially the architect to the engineer, which is terrible?
It is, and that's because the architects wrote it, right?
Exactly.
I use AIA contracts as a starting point. I very rarely see somebody who's willing to sign them just the way they are out of the box. So it's important to call those items out. Yeah, the architects wrote those things, so of course they favor architects.
The engineer's liable for everything.
Yeah.
Yes.
Back on one of the slides earlier, would another term for the construction management at risk, would that be a firm fixed price contract?
No.
No. That's a totally different animal.
A firm fixed price is just a way of saying we're going to pay you one lump sum for everything you're going to do for this project. There's no additional money for this scope. It is different from time and materials, where whatever time you take, whatever you use to finish this project, the owner's going to pay for. Construction management at risk is one contractor doing the design and the build under a guaranteed maximum price.
All right, thank you.
Mm-hmm.
What about named insured?
A named insured is a requirement, it's pretty standard, that you put the name of your client on your insurance policy. It is included typically with the insurance provider with their services. But if you have a lot of them, it can end up costing you more, and that's something you should factor into your overhead.
My problem client wanted to be named as an insured on my professional liability.
But, well, he can't do that, can he? No. For I think workers' comp, you can't do that on workers' comp either. So there are a couple of policies because of the way that they're written where they can't be additional insured. Again, your insurance broker should be someone that you know before there's a problem.
A small business person, should we feel confident in looking for unusual clauses in contracts, or do we have to run to the lawyer every time?
I don't know. If you were signing the same contract over and over again,
I'll give you a background.
Sure.
I presented an NDA to a potential vendor, do market research for me. He didn't want to sign the contract until his lawyer looked it over. The kicker is he happens to be one of our elected legislators.
No, I gotcha. Typically, you can go to a lawyer and say, I have this NDA. Are there any changes that you would not make? And he can give you guidelines. He can give you talking points for this kind of contract, right? You don't have to incur hourly rates every time you need a 2 or 3 page document signed. Now, if you are taking on the biggest project of your life, you are getting new insurance. You have never seen this form before. It is written in strange language. Yes, you should get an attorney. It's an investment in the outcome of that project. It's an investment in making sure that your bases are covered. They're not all jerks. Some of them are okay. But I would caution you that it's important to work with somebody who listens to you, right? And rather than maybe go out to find somebody at Smith Coriolis, who's probably the best, construction law firm in Georgia. Find somebody who you know well, who will just hear you out and maybe learn your business a little bit. Those kinds of relationships can be built over time. They can have tremendous value for a firm, a small firm. I think feeling like you're being heard is profoundly important in that relationship. Thank you for having me.
And on behalf of the chapter, a small token of our appreciation.
Thank you very much. Thank you very much. I will treasure it. It's a beautiful blue color. Thank you.
Don't forget the final clause.
The final clause.
I gave no legal advice.
Oh, that's right. That's right. Well, we started out there, so it doesn't have to be final. But no, you guys seem pretty smart.
We hope you enjoyed this presentation given at one of the Atlanta Metro Chapter meetings of the Georgia Society of Professional Engineers, an affiliate of the National Society of Professional Engineers. To find out more about us or to join us, check us out at gspe.org.